I have seen a lot in my 43 years on the bench. I have watched children sue their parents over furniture. I have watched siblings burn lifelong relationships over contested wills. I have watched people look me dead in the eye and lie without blinking about money, loyalty, and love. I have watched grown adults weep over parking tickets and shrug over broken promises. I have seen every version of human desperation this courtroom can produce. But what walked through my door on a cold Tuesday morning at exactly 9:43 a.m. stopped me before the session even began. Have you ever watched a son legally steal the home his own parents spent 38 years building and then stand in my courtroom smiling like he had done nothing wrong? If you want to see what happens when a scheme that calculated meets a judge who has seen every scheme there is, stay with me. And if you have not subscribed yet, do it right now. Because by the time this case reaches its end, you are going to want to have been here from the very beginning. The case file called it a property dispute. That is what it said on paper. Just another family disagreement over a deed, routine paperwork. The kind of matter I could typically resolve before lunch, sign off on, and forget about by afternoon. I had handled hundreds of cases just like it. I expected nothing different. But then Robert and Linda Miller walked through that door and I forgot everything I thought I knew about routine. Robert moved the way men move when they're carrying something heavier than age. His posture was straight, almost military, but it was the straightness of a man who had decided that if he allowed himself to bend even slightly, he would not make it through the morning. His jaw was set. His hands were still at his sides. His eyes were quiet in the way that eyes go quiet, not from peace, but from a decision, a silent, private decision, that whatever happened in this room, he would not break in front of the person who broke him first. Linda walked beside him. Her hands were folded in front of her. Her eyes carried something I have learned over 4 decades on this bench to recognize the moment I see it. Not anger, not confusion. Grief. The specific, irreversible grief of a person who trusted without reservation and was betrayed by the one human being in the world they never once imagined they would need to protect themselves from. The grief that does not arrive all at once. The kind that settles in quietly over weeks after the locks have already been changed and the garbage bags are already on the lawn and the realization finally arrives that the child you raised and sacrificed for looked at everything you built and saw not a home, but an opportunity. Their son, Jason Miller, sat at the defendant's table across from them, composed, polished, a neat stack of legal documents arranged in front of him with a kind of careful precision that does not happen by accident. He was not nervous. That was the first thing I noticed. Most people who sit in that chair carry some version of anxiety, even the ones who are right. Jason carried none. He sat the way a man sits when he believes the paperwork has already won the argument for him. And beside him, Chloe Bennett, still, watchful, her hands resting calmly on the table. There is a particular kind of stillness that belongs to innocent people caught in something they did not expect. And there is a different kind of stillness, a composed, deliberate kind that belongs to people who already know how the day is supposed to unfold. Chloe had the second kind. She was not anxious. She was waiting. And the difference between those two things told me more about this case in the first 30 seconds than the file had told me in 3 pages. I looked at Robert, I looked at Linda, I looked at Jason in his stack of documents. I have tried thousands of cases. I know the difference between a misunderstanding and a strategy. I know the difference between a family in conflict and a family in which one member has decided to use the others. I have seen financial manipulation dressed as love, control dressed as care, and exploitation dressed as responsibility more times than I can count. This was a strategy. What I did not yet know, what no one in that courtroom knew, was exactly how deep it went, how long it had been planned, and what those text messages were going to reveal when the bailiff placed them in front of me, less than an hour later. I picked up the case file, I opened it. Jason straightened slightly in his chair and slid the deed across the table toward the bailiff with the quiet confidence of a man who believes the conversation is already over. And in that moment, watching Robert Miller sit perfectly still while his son presented legal ownership of the home Robert had paid off the year Jason graduated college, I made a decision of my own. This case was not going to end the way Jason Miller had planned. To understand what happened in that courtroom, you have to go back 8 months earlier to a quiet evening, a kitchen table, a set of documents spread across the surface where this family had shared every meal for 3 decades. And to the words Hassan said to his father, words dressed as protection, designed as a trap. Dad, if you don't sign this, you could lose everything. That is where this story really begins. Jason slid the document across the table like a man playing his final card, slowly, deliberately, with the quiet satisfaction of someone who has been waiting for this exact moment. The deed was clean, notarized, dated 8 months prior. Robert Miller's signature sat at the bottom of the page in the careful, deliberate handwriting of a man who signs his name the way his generation was taught, with intention, with weight, with the assumption that his word and his signature still meant the same thing. On paper, Jason Miller owned the house. The courtroom shifted. I felt it, that subtle change in atmosphere that happens when a case that appeared to be about one thing quietly becomes about something else entirely. What had walked in as a story about wrongful eviction had just produced a legal document suggesting otherwise. I set the deed down. I did not react. I have learned that the moment a courtroom expects a reaction is precisely the moment to withhold one. Mr. Miller, I said, turning to Robert, did you sign this document? Robert was quiet for exactly 3 seconds. Not the quiet of a man searching for a lie. The quiet of a man who already knows the truth and understands, perhaps for the first time in that moment, what it cost him. Yes, he said, I signed it. Linda closed her eyes briefly, just briefly. Were you present, Mrs. Miller? I asked. I was in the house, she said carefully, but I was not shown everything. Jason said it was standard paperwork, estate planning. He said it would protect us. She paused. I trusted that he had read it. I looked at Jason. He offered a small, composed nod as if her words had confirmed something reasonable rather than something devastating. Who drafted these documents? I asked. Jason named an attorney, his attorney, one he had retained himself, paid himself, and arranged the signing appointment for himself at his parents' kitchen table on an evening he had selected with paperwork he had collected in advance. Did your parents have independent legal counsel present at the time of signing? I asked. They didn't feel they needed it, Jason said. I let that answer sit in the room for a moment. That is not what I asked you. Jason adjusted slightly in his chair. No, they did not have separate counsel. I wrote something down. I do not always write when something matters, but I wanted Jason to watch me write this particular detail. Robert spoke without being asked. His voice was low and even, the voice of a man rationing his composure carefully. I trusted my son, he said. That is the only reason I signed anything. I did not read every page. I have never needed to read every page of something Jason brought me. In 40 years, I never had a reason not to trust him. Linda turned her hands over in her lap. We thought he was protecting us, she said quietly. That is what he told us, that this was to make sure the house couldn't be taken if one of us needed medical care. He said it was for us. I looked back at the deed, at the date. 8 months ago, something was forming at the edge of my thinking, a pattern I had seen before, in different cases, with different names, but always the same shape underneath. Mr. Miller, I said, setting my pen down. When did Chloe move into the house? Jason's composure held. But only just, I'm not sure of the exact date, he said. I looked at him steadily. Then I suggest, I said, that you think carefully, because I am going to find out either way. 3 weeks. That was the answer. Once the records were produced and the dates were laid side by side where everyone in the courtroom could see them clearly, the deed transferred ownership to Jason on a Thursday in March. Chloe Bennett moved her belongings into the house on a Saturday, 23 days later. I looked at Chloe for the first time with a direct question. Miss Bennett, walk me through how you came to live in that house. Chloe's answer was immediate and smooth, the answer of someone who had rehearsed. Not the words exactly, but the tone. Casual, uncomplicated. The answer of a woman describing something ordinary. Jason and I had been together for a while, she said. He had his own home by then. It made sense for us to move in together. His own home, I repeated. The home his parents had lived in for 38 years. He owned it legally, she said. I am aware of what the paperwork says, I told her. I am asking about what happened inside the house after you arrived. What happened, according to Robert and Linda, was this. Within the first 2 weeks of Chloe's arrival, the utilities were transferred out of Robert's name and into Jason's. Robert discovered this not through a conversation, but through a disconnection. Notice that arrived in the mail. His name no longer attached to the account he had maintained for nearly 4 decades. When he asked Jason about it, Jason told him it was simply a matter of organization. Easier to have everything under one name now that the property had transferred. Then the household decisions began shifting. Grocery preferences changed. Common spaces were rearranged without discussion. Rooms Robert and Linda had used for years were repurposed quietly, gradually. The way you adjust the dial so slowly that the person in the room doesn't notice the temperature changing until they are already cold. Robert described it carefully, without drama. That was what made it land harder than any outburst could have. We started to feel like guests, he said, in the house I built my life in. Then came the locks. Linda was the one who described it. Her voice remained steady, but her hands folded in her lap, pressed together slightly as she spoke. We had a cardiology appointment, she said. Both of us, Robert's follow-up and my routine check. We were gone perhaps 3 hours. She paused. When we came back, the garage code did not work. I assumed it was an error. We went to the front door. The key did not fit. Another pause, longer this time. Our bags were on the lawn. 4 garbage bags and 2 boxes. The neighbors across the street were outside. She did not describe what that felt like. She did not need to. Jason's explanation was offered without hesitation and without apparent awareness of how it sounded. They needed space to transition, he said. I thought a clean break would be easier for everyone. I had already looked into apartments in the area. You changed the locks, I said, while they were at a medical appointment. The timing wasn't ideal, he said. I looked at him for a long moment. Nothing about this was spontaneous. Spontaneous evictions are messy, emotional, reactive. They carry the fingerprints of impulse. This one had carried logistics, transferred utilities, replaced hardware, bags packed and placed. All of it completed in the window of a 3-hour doctor's appointment, as though the schedule had been known in advance. Because it had been, I want to see the security footage from that morning, I said. The courtroom went very still. Jason's composure, which had held through every question until this moment, shifted almost imperceptibly a single degree of movement in his jaw, a fraction of a second's delay before his expression returned to neutral. Almost imperceptible. I have been doing this for 43 years. Almost is not enough. The security footage was 12 minutes long. The bailiff set the printed stills on my desk for 6 frames pulled from the timestamp sequence, each one labeled, each one clear. Then the full footage played on the monitor, positioned where the courtroom could see it. The date stamp in the corner read the same morning Robert and Linda had driven to their cardiology appointment. The first frame showed a moving truck parked in the driveway at 9:14 a.m., 11 minutes after Robert's car had left the street, not an hour later, not sometime that afternoon. 11 minutes. The second frame showed 2 men carrying a dresser through the front door, a dresser that did not belong to Robert or Linda Miller. The third frame showed Chloe Bennett standing in the doorway of the home, one hand resting on the frame, watching the movers work with the calm authority of a woman overseeing something she had organized herself. I looked at Chloe. She was looking at the table. The fourth frame showed Jason in the driveway, phone in hand, leaning against the hood of his car, not supervising, not moving anything, waiting. The posture of a man who has already done the work that mattered and is now simply present for the completion of it. The fifth frame showed the garbage bags, 4 of them lined up along the edge of the front lawn with the 2 boxes beside them arranged, not dropped, placed with enough order to suggest that whoever packed them had taken their time. The 6th frame showed the locksmith's van. Nobody in the courtroom spoke. I set the stills down and looked at Jason. Your parents were at their medical appointment, I said, and you had a moving truck in the driveway within 11 minutes of their car leaving the street. I knew they had the appointment, Jason said carefully. I thought it was a practical time. Practical, I said. I let the word sit exactly where I had placed it. Then the bailiff handed me the phone records. They had been subpoenaed the previous week, a detail Jason had been informed of and had not appeared particularly concerned about. People rarely understand until it is too late what a printed conversation looks like when it is read aloud in a room full of strangers with no context to soften it and no tone of voice to reframe it. I read them silently first, the entire exchange, beginning to end. Then I set the pages down and looked at the courtroom for a moment before I began. Chloe to Jason, 6 weeks before the deed transfer. Make sure it's finalized before we push them. Jason to Chloe the same evening. They won't understand the paperwork anyway. Chloe 2 weeks later. How much longer do we need to wait before it looks normal? Jason, another month, maybe 6 weeks, then it's done. And on the morning of the locksmith, sent at 11:32 a.m., while Robert and Linda were still sitting in a waiting room believing their son was protecting them. Jason to Chloe, it's done. I stopped reading. I put the pages down on the desk in front of me, and I did not pick up my pen. I did not write anything. I did not speak immediately. I have found, over 4 decades, that silence in a courtroom does more work than almost anything else available to a judge. It gives people nowhere to go. It removes the option of interruption and fills the space with exactly what the moment contains. What this moment contained was the complete and total collapse of every explanation Jason Miller had offered since he sat down. This was not estate planning. It was never estate planning. The language of protection had been borrowed, deliberately lifted from legitimate legal concepts and placed around a transaction designed not to shield Robert and Linda from risk, but to shield Jason and Chloe from having to wait any longer for a house they had already decided was going to be theirs. The timing of every event, the deed transfer, Chloe's arrival, the utility transfers, the gradual displacement, the locks, the bags on the lawn was not coincidence assembled after the fact into a suspicious pattern. It was a sequence, planned in text messages, executed on a schedule, completed while 2 people in their 70s sat in a cardiology waiting room trusting that their son was the kind of man they had raised him to be. Jason was very still now. The composed, document-ready version of him that had walked in that morning had gone somewhere. I did not think he was going to be able to retrieve it from. Chloe had not looked up from the table in several minutes. I leaned forward. "Mr. Miller," I said. My voice was level. It did not need to be anything else. This was not a family disagreement. This was not a misunderstanding about estate documents. This was not a son making a difficult but legal decision about property he owned. I let that land before I continued. This was premeditated. The word reached every corner of that courtroom and stayed there. Jason opened his mouth, then he closed it. For the first time since he had walked through my door with his neat stack of papers and his careful posture and his rehearsed explanations, he had nothing ready, and I was not finished. There are moments in a courtroom when the legal argument pauses and the human one begins. When the documents and the timestamps and the printed text messages step back, and what remains is simply a person telling the truth about their life in the plainest language they have. Robert Miller gave me one of those moments. He had been measured through the entire morning, controlled in the way that men of his generation are controlled, not because they do not feel things, but because they were taught that feeling things publicly is a kind of vulnerability they cannot afford. He had listened to the footage described. He had heard the text messages read aloud. He had sat perfectly still while a courtroom full of strangers absorbed the fact that his son had discussed the timing of his displacement the way you discuss a logistics problem. And then I asked him a simple question. "Mr. Miller, tell me about the house." He was quiet for a moment. When he spoke, his voice was low and undecorated. No performance in it, no appeal for sympathy, just fact, delivered the way a man delivers something he has carried so long it has become part of his bones. "I worked 42 years to buy that house," he said. "I paid it off the year Jason graduated college." The courtroom did not make a sound. "I worked construction for 19 years, he continued. "Then warehouse management. I was not a wealthy man. We were not a wealthy family. That house took everything we had for a long time. There were years we didn't take vacations. Years Linda worked double shifts so we could cover the mortgage and still put something away for Jason's education." He paused. "We paid his tuition in full, all 4 years. He never carried a student loan." I did not interrupt him. When Jason started his business, we gave him money to help with that too. $40,000 over 2 years. We told him it was a gift. We never asked for it back. Another pause, longer. When the business failed, we told him to come home. He lived with us for 14 months. We did not charge him rent. We did not make him feel like a burden. Robert's jaw tightened slightly because he was not a burden. He was our son. The word landed differently now than it would have an hour ago. I looked at Jason. He was looking at the table. The composed architecture of his morning had continued its quiet collapse, not dramatically, not all at once, but piece by piece, the way something carefully constructed comes undone when the foundation beneath it is removed. Linda spoke without being asked. Her voice, unlike Robert's, carried the first tremor of the morning, small but present, the sound of a woman who had held something in place through sheer discipline and had reached the limit of it. He was a good boy, she said. For a long time, he was a good boy. She pressed her hands together in her lap. He changed after Chloe moved in. Not immediately, gradually. The phone calls became shorter. He stopped coming for Sunday dinner. When we asked questions about the paperwork, he became impatient. Like we were bothering him, she stopped. I kept telling Robert it was an adjustment period, that it would settle. Her voice dropped. I told myself that right up until I found my clothes in a garbage bag on my own front lawn. I let the silence hold for a moment. Then I turned to Jason. Your parents paid your college tuition, I said, funded your business, housed you for over a year at no cost. And 8 months after your father signed a document, he trusted you to explain honestly your mother's clothes were in garbage bags. Jason said nothing. I want to talk about the transfer itself, I said, specifically the legal conditions under which it was executed. I opened the file to the section I had marked earlier. Your parents had no independent counsel. The document was prepared by an attorney you retained and paid. The signing took place in your parents' home, not in a legal office. And your father has testified that the transfer was explained to him verbally as a protective measure against medical debt seizure. I looked up. Are any of those facts incorrect? Jason's attorney leaned toward him briefly. Jason straightened. No, he said quietly. Those facts are correct. Then what we have, I said, setting the file down, is an elderly couple who signed a complex legal document without independent representation based on a verbal explanation provided by the party who stood to benefit from the transaction. I picked up my pen. That is not estate planning, Mr. Miller. That has a different name entirely. Jason's composure, what remained of it, was holding by something thinner than confidence now, something closer to habit. The transfer, I said, is going to need to withstand considerably more scrutiny than a notary stamp. I began writing, and the expression that crossed Jason Miller's face in that moment was the one I had been waiting for since he walked in with his documents and his certainty and his carefully arranged explanations. It was the expression of a man who had just understood, for the first time, that the paperwork had not won this argument after all. I have presided over enough property disputes to know that the law, when applied honestly, is not complicated. What makes these cases complicated is the distance between what the paperwork says and what actually happened in the room where it was signed. Closing that distance is the work, and by the time Chloe Bennett's financial records were placed before the court, the distance in this case had closed completely. The records told a clear story. At the time Jason initiated the deed transfer, Chloe carried substantial debt across 4 credit accounts. 2 had been referred to collections. 1 carried a balance that had nearly doubled in 14 months through accumulated interest and missed minimum payments. The total figure was not modest. It was the kind of number that changes the way a person looks at a house, stops seeing it as a home, and starts seeing it as a solution. I set the financial records down beside the text messages, beside the security footage stills, beside the deed dated 8 months prior with Robert Miller's careful signature at the bottom. Patterns, when you lay them flat and examine them honestly, tend to speak for themselves. Let me explain something for the record, I said, because I want everyone in this courtroom to understand precisely what the law recognizes and precisely why it exists. I looked at Jason first, then at Chloe, then I addressed the room. Undue influence occurs when one party uses their position of trust to override the free will of another in the signing of a legal document. It does not require physical force. It does not require open threats. It requires only that the influenced party trusted the influencing party enough to sign something they did not fully understand, based on an explanation designed to serve the influencer's interests rather than their own. I let that sit for a moment before continuing. Robert Miller signed a deed transferring his home of 38 years based on a verbal explanation his son provided. He had no attorney present. He was given no independent time to review the implications. The attorney who prepared the document was retained by Jason, paid by Jason, and present to serve Jason's interests, not his parents. I set my pen down. That is not a technicality. That is the precise set of circumstances undue influence doctrine was written to address. Jason's attorney shifted in his seat. Furthermore, I continued, fraudulent inducement occurs when a party enters a legal agreement based on a material misrepresentation made by the other party. Robert and Linda Miller were told this transfer would protect their home from medical debt seizure. That was the representation. The reality evidenced by text messages, financial records, and a moving truck that arrived 11 minutes after their car left the driveway is that the transfer served an entirely different purpose. I looked directly at Jason now. Your mother's cardiologist appointments were not incidental to this timeline. Your father's age was not incidental to this timeline. The absence of independent counsel was not incidental to this timeline. Each of these elements was a condition that made the strategy viable. I paused. You did not choose your parents by accident. You chose them because you knew them, because you knew how they trusted, because you understood, as their son, exactly where the vulnerability was. Jason opened his mouth. I am not finished, I said. He closed it. Chloe Bennett entered this relationship carrying significant financial debt. Within weeks of a property transfer that required no purchase, no mortgage, and no financial contribution from either her or your son, she was supervising movers into a fully paid home while the owners were at a medical appointment. I tapped the financial records. Motive is not difficult to establish when it is this clearly documented. I looked at Chloe. She had not moved in several minutes. The composed stillness from that morning had become something different now, not calm, but contained. The stillness of someone waiting to see how much further this goes. It was going further. Mr. Miller, I said, turning back to Jason, I am going to give you one opportunity to offer this court a legitimate explanation for why a deed transfer intended for estate planning purposes required your parents to have no legal representation, was followed within 3 weeks by your girlfriend's occupancy, was preceded by text messages discussing the timing of your parents' removal, and was executed on a morning your parents were at a doctor's appointment. I folded my hands. Take your time. What followed was not an explanation. It was the verbal equivalent of a man searching through empty rooms for something he had already lost. Jason spoke about intentions, about miscommunication, about how the plan had evolved differently than expected, about how he had always intended to find his parents suitable housing, about how the situation had become more complicated than he had anticipated. Not one word of it addressed a single specific fact I had placed before him. When he finished, the courtroom was quiet. I picked up my pen. This was not estate planning, I said. Estate planning protects the vulnerable. It does not require secrecy. It does not require the exclusion of independent counsel. It does not conclude with the protected party's belongings in garbage bags on a front lawn. I wrote something, I underlined it. This was isolation and control, executed with legal instruments, dressed in the language of protection, and designed to transfer an asset from 2 elderly people who trusted their son to a son who had calculated in writing that they would not understand the paperwork. The line landed in the silence of that courtroom and stayed there. Jason had no expression left to arrange. Whatever composure had walked in with him that morning was entirely gone. Beside him, Chloe was very still and very quiet in a way that suggested she had finally understood that stillness was no longer going to be sufficient. I set my pen down. We will take a brief recess, I said. When we return, I will deliver my ruling. I gathered the file, the deed, the text messages, the financial records, the security footage stills, the testimony of 2 people in their 70s who had worked 4 decades for a house and raised the son in it and trusted him without reservation until the morning they came home from a doctor's appointment and found their lives in garbage bags on their own front lawn. I did not look at Jason again before I stood. There was nothing left in his direction worth looking for. I have delivered thousands of rulings in this courtroom. Some of them were simple, some of them were difficult, some of them required me to set aside what I felt and apply only what the law permitted. And some, the ones that stay with you, the ones you carry home and think about in the quiet hours, are the ones where what you feel and what the law permits arrive at exactly the same place at exactly the same time. This was one of those rulings. I returned from recess, took my seat, and opened the file one final time. The courtroom settled into the particular silence that precedes a verdict, the kind of silence that everyone in the room fills privately with whatever they are hoping or dreading to hear. I looked at Robert first. He was sitting the same way he had sat all morning, straight, still, jaw set. But something had shifted slightly in his eyes, not hope exactly, but the careful, guarded posture of a man allowing himself to consider the possibility of it. Linda sat beside him with her hands folded and her eyes on mine. I began, in the matter of Miller versus Miller, this court finds as follows. I set the pages down and spoke directly, without notes, because what I had to say did not require them. The deed transfer executed 8 months prior is ruled invalid on 3 grounds. First, undue influence. Robert and Linda Miller signed a complex legal document at the direction of a party who stood to benefit substantially from that document without independent counsel, without adequate time for review, and based on a verbal explanation that misrepresented the purpose and consequence of the transfer. The law does not recognize consent obtained under those conditions as informed consent. Jason was very still. Second, fraudulent inducement. The transfer was initiated under a material misrepresentation. Robert and Linda Miller were told the transfer would protect their home. The evidence before this court establishes beyond reasonable question that the transfer was designed not to protect them, but to displace them. Those are not the same thing. They are, in fact, opposites. I turned a page. Third, lack of independent legal representation for the transferring parties in a transaction of this magnitude, combined with the documented financial motive of the benefiting party, renders the transfer unconscionable under the circumstances in which it was executed. I set the file down. This court therefore orders the following. Ownership of the property is to be restored immediately and in full to Robert and Linda Miller. All title documents are to be amended accordingly and filed within 14 days. Jason Miller is ordered to cover all legal costs incurred by the plaintiffs in bringing this matter before the court, in addition to any reasonable relocation and restoration expenses Robert and Linda Miller have accrued since the date of their removal. I paused. Furthermore, given the evidence presented, specifically the text message communications, the financial records, the timeline of the transfer and subsequent occupancy, and the manner in which the deed signing was arranged, this matter is being referred to the district attorney's office for review of potential elder financial abuse. The sound Chloe made was not quite audible, but her head turned slightly, and for the first time all morning the composure she had maintained with such deliberate care showed its first visible fracture. Jason did not move, did not speak, did not look up. I looked at him for a long moment before I said what I had decided, sometime during recess, that I was going to say, not as a legal finding, not as a procedural instruction, but as the plain truth of what I had watched unfold in my courtroom over the course of a single morning. Mr. Miller. He looked up. His eyes were the eyes of a man who had arrived with a plan and watched it disassemble piece by piece and now had nothing left behind them but the residue of what the plan had cost him. You were given something most people never receive, I said. 2 parents who paid your tuition, funded your failures, opened their home to you without condition, and trusted you without reservation for the entirety of your adult life. You took that trust and you converted it into a legal instrument. You used the language of protection to execute a plan of extraction. And you did it in writing on a timeline while your mother was at a cardiology appointment. I leaned forward slightly. You don't build a life by dismantling the people who built yours. The courtroom was absolutely silent. Robert reached over and took Linda's hand. It was a small gesture, quiet, the kind of thing that happens between 2 people who have shared so much for so long that they no longer need to announce what they feel. They simply reach for each other the way people reach for something solid when the ground has been unsteady for too long. Linda did not look at Jason. She looked at her husband's hand covering hers, and she let out a breath that seemed to carry the weight of 8 months in it. Chloe looked away. Jason said nothing. There was nothing left to say that the morning had not already said for him in timestamps and text messages and security footage and financial records and the testimony of 2 people who had loved him without calculation for his entire life. Court was adjourned. I have thought about Robert and Linda Miller many times since that Tuesday morning. I think about the 42 years, the double shifts, the mortgage paid off quietly without ceremony. The same year, a son crossed the graduation stage without any debt attached to his name because his parents had decided, long before he ever asked, that he would not carry that weight. I think about the garbage bags on the lawn, about neighbors watching, about a garage code that no longer worked and a front door key that no longer fit and a cardiology waiting room where 2 people in their 70s sat believing in that moment that their son was still the person they had raised. I think about what it costs a person to trust completely and what it costs them when that trust is not only broken but weaponized, gathered up, and used as the precise instrument of their displacement. The law has specific language for what Jason Miller did: undue influence, fraudulent inducement, elder financial abuse. These are useful words. They are the words that allowed this court to act, to restore, to refer, to rule. But underneath those words is something simpler and older and far more devastating than any legal definition. A son looked at everything his parents had built and saw not a legacy, but an asset. And he almost got away with it. Almost because the paperwork was clean, because the notary stamp was legitimate, because on the surface, the documents said exactly what Jason needed them to say. This is what makes cases like this one so dangerous and so important. The manipulation was not crude, it was careful. It was dressed in the vocabulary of protection and executed with the patience of someone who understood that the people he was deceiving trusted him too completely to look closely at what they were signing. That is the nature of this particular kind of betrayal. It does not announce itself. It arrives quietly in a kitchen at a table where a family has shared 10,000 meals, wearing the face of a son who says, "I am doing this for you." Justice, in a case like this one, is not simply about returning a deed to its rightful owners, though that matters enormously. And it was done. It is about recognition, about a courtroom looking at what was actually done beneath the language it was dressed in and calling it by its real name. I have been on this bench for 43 years. I have learned that behind every signature, there is a story. And sometimes, not always, but sometimes behind that story, carefully hidden beneath the notary stamp and the legal language and the explanations that sound just reasonable enough to believe, there is a setup, and it is my job to find it.